Hello, good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once the webinar has ended, if you would take a moment to complete the brief survey, we do appreciate it. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It's now my pleasure to introduce today's moderator, Adam Masterleo.
Kathy, thank you so much, and welcome everyone to this week's installment, our weekly business update. We have a great program for you today, some new speakers who are going to give presentations on topics that are extremely timely and relevant. Before we get started, I'm going to introduce Tom Iran. Tom is the chair of our Labor and Employment Department here at Bond. And Tom is going to give us a little preview of some presentations that are going to be coming up in the future.
Good afternoon, everyone. We've reported here before on President Biden's pro-labor agenda, and we're starting to see that agenda take action. Last month, he appointed a new general counsel at the National Labor Relations Board, Jennifer Abrazo, who has a history of working at the board and was most recently counsel for the Communication Workers of America. And she has begun to establish her staff, which includes a number of union attorneys. And one of her first acts as general counsel to issue a memo to the field, to the regional offices, on the cases that she wants to review with an eye toward reshaping multiple legal principles. The net that the general counsel has cast is vast and will implicate both the operations and employment practices of non-union employers, as well as the terms of existing employer-union relationships. So let me give you just a couple of examples of the targets that the general counsel has identified. First, employment policies, employment rules. And we've seen them before, right? So the labor board is going to examine our social media policies, policies on acting in a respectful and professional manner, our policies on confidentiality and communications with the media and the use of cameras and recording devices, all with a asserted concern that these policies, which regulate employee conduct, can interfere with their Section 7 rights. We can anticipate that the balance that currently exists in the law will become heavily weighted in the favor of employees and unions. Second area where the general counsel has expressed interest is in confidentiality. Both the confidentiality during investigations and confidentiality in NDAs in the settlement of claims and in arbitration agreements, individual arbitration agreements. Again, the notion that by requiring or agreeing to a confidentiality provision, the employer is somehow limiting the employee's right to engage in concerted protected activity or participate in a future claim. Though in most of these cases, it's a voluntary settlement and often with the advice of counsel. The general counsel has also indicated that she intends to re-examine the rules around the use of email, the employer's email system, and we can be assured that this will extend to Zoom and Teams and other social media programs, virtual programs that employers now use, as well as the employer's computer systems and mobile devices. Again, with a notion that is there appropriate access for union activity, for union organizing, disrupting the rules that are already in place there. Talking about union access, the general counsel has also indicated an interest in the cases dealing with the right to have, for unions to have access to private property. And in particular, this question of public areas within private property. So a restaurant within a casino or a cafeteria within a hospital system? What rights does the union have to access that property? This is just highlights of the policies that will affect, or the cases that will affect both unionized and non-unionized employees and employers. With respect to unionized employers, there are a couple of other areas that are important to point out. The first is the extent to which the board will allow a collective bargaining agreement to control a dispute. Will give the union a second bite at the apple by having a claim process both under the grievance and arbitration procedure and before the labor board. The General Counsel has also asked to review those cases that deal with what limits are placed on an employer after a collective bargaining agreement expires, such as how can the employer react to a union strike tactics, and whether the employer is required to continue to collect union dues even though the contract is expired. And finally, one to mention in the unionized environment is the union's representation during disciplinary investigations. And one of my favorite questions that the General Counsel is reviewing is whether the employer should be required to provide the union in advance the questions to be asked in all of the discipline investigatory interviews. So why do we raise this with you today? Here's the punchline. The General Counsel is looking for cases to serve as the basis to change the law. None of the hundreds of folks who are on this call want to be that test case. We need to be attentive now to our decisions in these areas to avoid that fate. Our department will be conducting a series of webinars, some for non-union employers and others for unionized employers, to keep you abreast of these developments and provide counsel as it relates to the General Counsel's advancements. Stay tuned for information on those, and be mindful of the action in Washington as we turn now to the action in New York, and particularly coming out of Albany. So I'll turn it back over to you, Adam. Thanks very much.
Tom, thank you. And everyone keep that on your radar. Coming up, we will advertise when those presentations are going to be given. There's a lot there at the federal level for employers to be aware of. So thanks, Tom. All right. Like Tom said, we are going to move on to some state issues. And here with us today to discuss one of the most recent regulations that came from Albany is Sanjeev D'Souza. Sanjeev is a member in our Albany office, works with a ton of our healthcare clients, providing guidance. And so Sanjeev has digested this regulation and is going to give us a presentation about it. So Sanjeev, please take it away.
Thanks, Adam. And thanks for joining us, everyone. We appreciate it very much. So as Adam mentioned, I'm going to focus my comments on the emergency vaccination regulation that came out last week. And so this is really focused on something that our healthcare clients need to pay close attention to. The regulation is applicable to them. The reg went into effect last Thursday, so August 26th, and it was issued by the Department of Health's Public Health and Health Planning Council. It is available, I believe, online. Katie, you can correct me if I'm wrong, but it has been published in some form, and it's a lengthy document, about 25 pages, but a lot of it is focused on sort of regulatory impact statements. The regulation itself is about 3 or 4 pages long. It was issued on an emergency basis, and it replaces the DOH's Section 16 order that was issued the previous week, so August 18th. The commissioner has issued notices to covered entities that this emergency reg replaces the Section 16 order, and the 16 order is essentially rescinded. In a sort of 30,000-foot nutshell, What this regulation requires is that personnel affiliated with covered entities be fully vaccinated against COVID-19. And it sets two important deadlines. So if you are a general hospital or a nursing home, your personnel need to have at least a first dose by September 27th. For all other covered entities, personnel need to have their first dose by October 27th. I'm sorry, that's the wrong date. October 7th. We apologize. That's a typo there. October 7th. We will correct that in the slides that are made available. Could we go to the next slide, please? So let's spend a moment talking about covered entities. The reg specifies the different entities that are considered covered. First, it's any facility that's included in the definition of a hospital under Public Health Law Section 2801. And the reg specifically references general hospitals, nursing homes, diagnostic and treatment centers. But keep in mind, that's not a conclusive or a comprehensive list. It's any entity or any facility that's defined as a hospital under that section. Second, it's any agency that's established under Public Health Law Article 36, which would include certified home health agencies, as well as acquired immune deficiency syndrome or AIDS home care programs. Third, hospices are considered a covered entity, as well as adult care facilities under Article 7 of the Social Services Law. So in addition to covered entities, the regulation defines personnel. And that is a very broad definition that's used here, modeled according to the Department of Health after regulations that are applicable for getting mandatory measles and rubella vaccines. So personnel are defined as all persons either employed or affiliated with the covered entity. And so that's folks who are paid or unpaid and can include employees, medical and nursing staff, contracted personnel, students, volunteers, and the catch-all, which is any other affiliated person who engage in such activities that if they were infected with COVID-19, they could potentially expose other covered personnel, patients, or residents to the disease. And so if you're a hospital and you have EMT personnel coming in, they would likely be considered affiliated persons who would need to be vaccinated because they could come into contact with patients or residents or others and potentially expose them if they are infected. Essentially, this definition would cover almost everyone who enters a covered entity because they are likely to have some contact either with other covered personnel or with patients or residents or visitors. It doesn't encompass patients or visitors, though they're not subject to this vaccine requirement. Next slide, please. So the regulation also does provide for an exemption that could potentially be granted for a medical reason. Keep in mind, though, and you'll see this in the regulation language itself, it's a narrowly defined exemption. So for one thing, it requires that there be a medical certification, a written medical certification provided. That certification needs to be issued, and it's limited specifically in the reg to two practitioners. So a licensed physician or a certified nurse practitioner. It doesn't provide or permit for that certification to be issued by other healthcare providers. And the certification essentially needs to establish that immunization with COVID-19 vaccine would be detrimental to the health of the individual based on the individual's pre-existing health condition. And the reg specifically notes that the exemption is applicable while that condition creates this detriment to the person's health or the risk of a detriment to their health from immunization. It's no longer applicable once that immunization is no longer detrimental to their health. There isn't any further guidance or explanation included in the regulation on what that exactly drills down to. We may hear more in the weeks coming, in the upcoming weeks, excuse me. And there have been notations made by DOH representatives in recent webinars that employers are expected to carefully scrutinize that certification and shouldn't simply defer to an employee's provider, making a statement that they shouldn't get the vaccine if it doesn't fit within this standard. So there is a level of scrutiny that's expected of covered entities if they are considering whether an exemption needs to be granted. So can you go to the next slide, please? The reg also requires of covered entities that they maintain certain documentation. One is proof of vaccination. And there are a couple of options in terms of the type of proof of vaccination. One would be a signed document by the administering healthcare practitioner that this vaccine was issued and administered to the individual. It could include a CDC COVID vaccination card. Alternatively, an acceptable proof of vaccination could be an official record that comes from a foreign country, and there are a couple of other cited agencies or entities from which that record could come. New York State Countermeasure Data Management System, CDMS, or the New York State Immunization Information System, NYSIIS. And then the catch-all language, which is any other documentation that's determined acceptable by the Department of Health. As of this today's webinar, I'm not aware of any other documentation that's been deemed acceptable by the department. We'll see. The other record that covered entities need to maintain is records of the medical exemption if one is granted. So that should encompass a certification, the certification that's required, as well as documentation on the type of accommodation that's being provided and how long this is going to be in place. That needs to be maintained in writing by the employer. And as far as where you should be maintaining these records, the regulation notes that it should be maintained in personnel files in accordance with privacy laws. We generally consider that to be that private medical record file that the employer maintains confidentially for the employee to make sure that it doesn't, it's not in a personnel file, for example, that might have a much broader right of access amongst supervisors and managers. So maintain those records confidentially, keep them in the separate medical file. Okay, let's move on to the next slide, please. So in addition to that documentation, which an employer may need to, or covered entity may need to provide on request, the reg also requires that additional documentation be maintained and reported and submitted to the Department of Health upon request. And that is data on the number and percentage of vaccinated personnel, number and percentage of personnel granted medical exemptions, and then the total number of covered personnel. So not names of individual employees or affiliated personnel, but data, so numbers and percentages. Additionally, the reg expressly requires that covered entities have a policy and a procedure so to maintain compliance with this reg. It needs to be in writing, it needs to be available so that upon request, you can provide it to a Department of Health representative. And then the department also notes in the reg that they may still require additional measures such as a face covering for all personnel. They reserve the right to do that. That could apply to both vaccinated and unvaccinated individuals. If that happens, that face covering, for example, would need to be provided at no cost to the employee or to the individual who's covered. Next slide, please. So a couple of closing points, so to speak. So there is no testing alternative to vaccination under the regulation. a covered individual couldn't avoid the vaccination by having weekly tests and satisfy the regulation. The other difference, the other aspect of this regulation that stands out is there is no mention of a religious exemption being available to covered personnel. And that is in contrast to the rescinded Section 16 order, which expressly indicated that both medical and religious exemptions are available. My understanding is that there was a webinar that was put on by the Department of Health last week where DOH counsel noted that religious exemptions were not permitted under this regulation and believed that this was a constitutionally defensible position for the department to take. Did not, as far as I know, cite to any specific authority to support that position, but that at least was what seems to have been communicated verbally by counsel during the webinar. Counsel did not address two other laws that are applicable here or potentially applicable, and the first is Title VII, which protects against religious discrimination and includes an affirmative obligation on employers to consider religious accommodations for employees so long as they don't create an undue hardship. And the state equivalent of that in New York is the human rights law, which also requires that employers provide religious accommodations that don't cause undue hardship. That is a question that in my mind, is not completely answered by this regulation or the statements by the department's representatives thus far. I think there will be more to consider and likely more coming out on this question, because I'm sure many employers have this question who are covered. They may be getting these requests from employees who are reluctant or unwilling to get the vaccination. And we will know more hopefully soon. Hopefully there will be some guidance coming out from the department. But in the meantime, employers who are covered need to keep in mind that those two laws also exist in making decisions about how to handle requests for exemptions. Lastly, this is a temporary regulation. And so it is in effect for 90 days starting August 26th. DOH has the right to extend the duration while it remains in effect, or they can go an alternative route and issue a notice of proposed rulemaking to permanently adopt this regulation. So I'm sure we will also hear more about that in the weeks coming. My final comment is there are no specific penalties identified in the regulation itself for non-compliance. DOH counsel indicated last week that there may be some guidance coming out shortly. Non-compliance penalties may be addressed there as well, but we don't know at this point. So that's a 30,000-foot overview of this emergency regulation. I'm sure there are many questions surrounding it. We will do our best to answer those questions both during this webinar and afterwards. And you can always reach out to me or to others in our labor department, in our group, with those questions, and we will work with you to provide responses. So thanks very much for the time. I appreciate it.
Sanjeev, thank you so much. That was great. I will note that we have received a ton of questions in the Q&A about whether or not your particular business qualifies as a covered entity. I will say that if it's not clear, then you're going to need to talk to somebody. So you're going to need to reach out to the bond lawyer who you typically work with, or if you don't typically work with a bond lawyer, now is a great time to start. So reach out to your bond lawyer who can analyze that question for you and give you some guidance. So thank you, Sanjeev. I really appreciate it. I know everybody on does as well. All right, moving on. Our next topic is something that has come up quite a bit. And Sanjeev kind of touched on it a little bit, but we're going to dive into it a little more deeply. And that is, what are these accommodation issues? So you all know by now that if you're going to have a vaccine mandate, you have to provide accommodations for medical and religious reasons, although maybe not pursuant to that regulation, as Sanjeev discussed. But here to talk to us about that today is Travis Tallarico. Travis is attorney in our Rochester office who counsels clients on these issues regularly. So Travis, please take it away.
Thank you very much, Adam, and I appreciate everyone tuning in today. I see already in the chat that we've been getting a lot of questions regarding religious accommodations, so hopefully this presentation will be helpful for us today. In a nutshell, I'm going to walk us through just kind of basic overview of what an employer needs to do to properly navigate the religious accommodation process, and then try to tie that into how accommodations or responses to accommodations in response to a mandatory COVID-19 vaccine policy apply. So if we can move on to the start of the slides, please. Thank you. So beginning with the federal law, under Title VII, it is an unlawful employment practice for an employer not to make reasonable accommodations or an undue hardship for the religious practices of the employee or the employer's employees and prospective employees. I'll be getting into what an undue hardship looks like for an employer a little bit further on in the presentation. Now, Title VII also provides that the term religion encompasses all aspects of religious observance and practice along with belief. So this is important to consider, and I imagine, particularly now, imagine that we're going to be seeing an influx in these types of accommodations in response to vaccine mandates, in determining and inquiring into if an employee actually truly does have a sincerely held religious belief, which would prohibit them from getting the vaccine. Next slide, please. So the standard under Title VII for a plaintiff to make out a case of religious discrimination, they would have to show, as mentioned, that they actually did hold a sincerely held or bona fide religious belief conflicting with a requirement, an employment requirement of the organization, that they actually did inform their employer of this belief, and that they were disciplined or suffered some sort of negative action for failure to comply with the conflicting requirement. Now, once this case is established, the burden then shifts to the employer to offer that reasonable accommodation unless the employer would suffer an undue hardship. And in the context of religious accommodations under Title VII, an accommodation will result in an undue hardship whenever it results in more than a de minimis cost to the employer. And I will extrapolate more on what a de minimis cost is a little bit further on. Next slide. Now, how is religion actually defined? So in general, the Supreme Court and the Second Circuit take a very expansive view of what religion is. And it's important to note that if an employee does come forward with a religious belief, it does not specifically need to be a tenet of the religion that they are a member of. It doesn't need to be a well-known belief. It just needs to be sincerely held and involve some sort of a spiritual aspect to it. Social, political, or economic views or any sort of preference are not religious beliefs protected by Title VII. I think this is really important to note, especially in the vaccine context, because if an employee does come forward, regardless of how strongly they may feel if they think that there is a scientific reason behind not getting vaccinated, if they feel that it's not in their best interest, this is not sufficient grounds to be encompassed under a religious exemption. And generally speaking, it is best for an employer to take an employee's belief at face value and believe that they do have a sincerely held religious belief in whatever they are asserting and how that ties into the employment activity. However, the EOC in guidance released this year has held that if there is an objective reason for an employer to question the sincerity of the belief or want to learn more information, understand why that belief would interfere with the employment practice, the employer is allowed to inquire and seek additional support to verify that belief. Next slide, please. Now, shifting to application of the undue hardship standard under state law, under Executive Law Section 10, Section 296, subsection 10, the standard is rather than just an undue hardship, it is defined as a significant expense or difficulty for the employer. Now, in understanding that, this section does provide some guidance as to what may be a significant expense or difficulty. And those things could be interference with a safe or effective workplace, violation of company policies or seniority systems, the economic cost of the accommodation, and the number of employees who are making the request for the accommodation. Now, with that being said, generally, New York courts seem to defer to federal courts and the Title VII application of an undue hardship when determining this type of, when determining what actually is or is not an undue hardship in these settings. So essentially, even cases brought under New York law tend to be evaluated under the de minimis standard, essentially rendering this slide not all that relevant, but some good background. Next slide, please. So now we're probably all asking what actually is an undue hardship. And unfortunately, I do not have a clear-cut answer to that question. These types of cases, these types of requests are going to have to evaluated on a case-by-case basis, and it's going to determine on the type of employer, the nature of the position, essentially the internal operations of the company. But to provide some examples, some of which were addressed in the last slide, could be the cost of providing the accommodation, interference with workplace health or safety, also public health or safety, particularly relevant to the recent vaccine mandate for healthcare workers, legal risk. So with legal risk, an employer is not obligated to accommodate an employee if doing so would put them at jeopardy of legal risk of violation of a conflicting state or other law or statute. Again, also applicable to the recent New York State mandate. Violation of existing company policies or seniority systems, and disparate impacts on other employees. And what I mean by disparate impacts on other employees, we see this come up a lot in the context of an employee who may have a need a religious accommodation in terms of working certain hours where their religion would prohibit them from working certain shifts or certain days of the week. And if that request would disparately impact other employees, Title VII does not allow for that. So a religious accommodation for one employee cannot negatively impact other directly, which is important to keep in mind. Next slide, please. So this case listed here is a Massachusetts case, and I wanted to include this in our presentation today because I think it is illustrative of how courts may apply the undue hardship standard, particularly in the public health setting, as this is a case involving a hospital. But I also think that it's instructive moving forward to how courts might apply this even in non-health related settings. So it's just a brief summary of the facts of the case for everyone to understand what happened here. The plaintiff in that matter, the employer, their hospital network, implemented a flu vaccination policy and informed everybody that they had to receive the vaccination by a certain date. If they didn't, they would be terminated. Plaintiff claimed a religious exemption, and the employer worked with her to try to accommodate her to a different position. They allowed her to use her paid time off to try to help her find another position. They helped her look for a position internally. And they also extended some additional leave before she left to help her find another job. And the important takeaways here is that the process that the employer went through in allowing working with the employee in the interactive process to help her look for another job, help her find a position internally, was a sufficient attempt at reasonable accommodation. And also equally as importantly, if not more so, given the COVID vaccination setting, is the court did hold that in a public health setting, it would have been an undue burden on the employer to allow an unvaccinated employee who was patient-facing, seeing patients on a day-to-day basis, to continue in that role while being unvaccinated. Even other possible alternatives, such as masking or any sort of healthcare testing, the court said that was still an undue burden on the employer due to the potential risk it could pose to the public, to the safety and welfare of the public and patients coming in and out of the hospital. Next slide, please. So dialing into what accommodations may look like if you do have an employee who comes to seeking a religious accommodation request. as Sanjeev talked about in his presentation, it's a little bit iffy right now how this applies to the mandate that went into effect last week. As Sanjeev also mentioned, the regulation does seem to be directly in conflict with both Title VII and the New York State human rights law in seemingly not allowing for religious accommodations. So this is something we'll obviously be keeping you all posted on if the Department of Health does provide more guidance on this area, as if religious accommodations are permissible or not under the regulation. Now, for everybody else who does not work in a healthcare setting, some possible accommodations or attempted accommodations that you might be seeing or might want to think about providing are mask mandates or social distancing policies, which have been in common practice for a while now, evaluating if an employee may be able to work remotely, possibly requiring mandatory testing for employees, which would be paid for by the employer. Relocation to a different role. So essentially, if it was a client-facing role or a role where the employee would be working actively with other people in the company, possibly relocating them to a role where they have less face-to-face contact with people. Shift changes for the similar reason as just discussed. And also, as discussed in the Robinson case a couple slides ago, potentially working with the employee and helping them find a new position if your organization does decide to implement a mandatory vaccine policy and you find that it would be against your interest to allow any sort of an accommodation here. Next slide. So in conclusion, as I alluded to earlier, unfortunately, we've been getting some questions from our clients if there's any real bright line rules as to what is or is not an undue burden and what may or may not be a proper accommodation. And unfortunately, it is important that these cases are evaluated every time that you get a request. Sit down with the employee, work with them, work to understand their belief, walk through the interactive process. So do actually engage in the process of seeing if a reasonable accommodation is feasible. And then that's the point where it'll be a decision within your organization. And the purpose that we're all here for is to consult with us and say, hey, here's what's going on. This is the possible things we can offer. We do or do not want to do this. How should we move forward? So this is going to be an evolving area as more employers start to put in vaccine mandates, and as we start to see more and more cases in this area. So again, this is something that's evolving for us. It's evolving for you, and we're here to answer all questions as in a timely fashion as we move forward. So thank you all, and looking forward to seeing some of the questions.
Travis, thank you so much. I know that's a question I've been getting asked quite a bit by clients, specifically, when is a religious accommodation appropriate? What accommodations work? So thank you, Travis. Appreciate it. All right, last but not least is going to be Kate with our Albany update, and she's going to talk about a lot of things, including the new mask guidance that came out. So Katie.
All right. Yes. As always, we have lots to talk about today, so let's get going. The good news that we've been talking about for weeks here, you see this curve is flattening. It's very interesting because this outbreak is doing way more of a plateau than the other outbreaks have done. They really spiked and then came down pretty quickly. This is plateauing. And so the good news is that things are slowing down. The bad news is that we're still not coming back down yet. Cases are still increasing in New York. The bottom category of this is the daily average from yesterday. So as you can see, over the past 14 days, we've seen a 6% increase in cases. Compared to last week we had seen a 38% increase in cases. So hopefully by next week, we're going to see a 0% increase in cases. That's what we can hope for in the state of New York. The other good news is that we're looking at our hospitalization numbers as well. The governor gave a COVID update at 11 o'clock this morning, said in it that New York's hospitals are 1/3 full. So we're not at the point of really needing to be very concerned, but it is something to watch. But given that the rate is decrease or is slowing down, we have less to worry about there. Looking at vaccination progress, we've ticked up 1 percentage point in each category since last week. Was really happy to see that we have 80% of New Yorkers who are 18 and older have received at least one shot. And then out of all New Yorkers, 60% are now fully vaccinated. Again, these numbers, you know this, for weeks they were dragging, they weren't going up at all. And now we're actually seeing a concerted effort to do so. Also today, the governor announced that the state will be allocating $65 million to local health departments to get them ready, basically, to do booster shots. There has been talk over the past, a few days about whether or not the booster shots will actually apply to people 6 months after they take their shot. But given the good news coming out of Johnson & Johnson showing that receiving a booster shot with Johnson & Johnson really does help the efficacy of that vaccine, we may continue to see this booster issue is really going to be coming to the forefront over the next few weeks. So it looks as though county health departments and local health departments are really going to be the ones that are empowered in this chapter of the pandemic. The governor's address today, she said, we're going to have, things in place from the state, but it's really going to be up to the local health departments to make a lot of decisions. And, notwithstanding the vaccine mandate and notwithstanding the mask mandate that I will be talking about, once it becomes no longer necessary to have those in place, she seemed very open to adjusting it. So I think we're going to be entering a more flexible period of the pandemic once we see cases go down. Turning to the mask mandate. So this applies to public places, and most notably, it applies to schools. We've been getting a lot of questions about this, so hold tight. I have a lot of slides on it. This commissioner's determination order came out on August 27th. It goes along with the regulation, which was on the prior slide. You use these two things together to interpret what is actually happening. So the easiest places to look at are healthcare settings, adult care facilities, correctional facilities, homeless shelters, and public transportation. Everybody has to wear masks there, regardless of your vaccination status. Those are not new things. We've been looking at that for quite some time now. But what is new is this: schools. In pre-K through 12 schools, there is no exception. This is a very straightforward rule. Masks need to be worn at all times while indoors, regardless of the vaccination status of anybody. The only exceptions to this rule are eating, drinking, singing, or playing a wind instrument. At that point, you have to be spaced 6 feet apart from one another. That's it. Those are the only exceptions here. So I know there's going to be a lot of questions about that. I deeply encourage you to reach out to a bond attorney with your specific questions about it, because this rule is pretty straightforward. That's when the masks need to be worn. There's no local discretion here. This is an order from the state. There are penalties that apply. The penalties are $1,000. Whether or not they apply to the individual, to the entity, those are the things that you will need to speak with your attorney about, because of, we have to look at each situation kind of holistically. So turning to other Albany developments, we have two really big things on the mind right now. One, the legislature is likely coming back tomorrow. They are likely going to be passing an extension to the eviction moratorium. How it looks is going to be, it hasn't been released yet. Those details are being hammered out right now. It appears that it will be extended until 2022. It appears that it's going to really focus on trying to get money out the door as well. Remember that under this rental assistance program, that if you receive that money, then you can't be evicted for a year after receiving that money. So that's part of the condition there. So they're really trying to funnel people to this money that exists. while the payments are going faster out the door, that was something the governor said last week was going to be one of her top priorities. There's still a lot of payments that need to be made. So far, we have $605 million worth of payments that need to be made. They've been promised by the state. The applications have gone through. It's just the payment needs to go through. So that will be happening there. And then finally, I will mention the HERO Act, because I knew I was going to get questions about it, and I was right. There has been a lot of talk lately about reactivating the HERO, or about activating the HERO Act to apply to COVID. A lot of pressure is being put on the governor to direct the Department of Health to do so. The sponsors of the bill, of the HERO Act legislation, are pushing very hard for COVID-19 to be activated under the HERO Act. I know the next question that's going to come out of you, will they do that? Is the state going to have the Department of Health do that? The answer is, I don't know. I can't even give you a percentage chance that I think it might happen. I have no idea whether or not it's going to happen. This is a very up in the air situation. Given that we're seeing the cases plateau here and will likely be going down soon in New York, I'm not sure that it's going to be activated. But there's a lot of economic concerns. Obviously, the HERO Act will be expensive to implement. But we will continue to watch that extremely closely. One other reminder with the HERO Act, a written copy of your HERO Act plan needs to be distributed to all of your employees by September 4th, 2021. It is August 31st, so September 4th is coming right up. It's this week. So make sure that you're getting that out the door to your employees. Again, it's a written copy of the plan needs to go out to them. And if you have questions on that, again, please reach out to any of us. We're always happy to help. And with that, I will kick it back to you, Adam.
Katie, thank you so much. Thank you to everybody who attended today. Thank you to our presenters. We will be back next week. Who knows what the rest of the week holds? So we will make sure to update you next week, and we'll see you at noon.